Welcome to the Culture Law Podcast, and welcome to Washington Law. This podcast is separate from my role as an attorney. However, it is my job to educate and teach and to put into context for you. And today we're talking about our second video on the Darrell Brooks trial and essentially how his criminal history was withheld from the jury, including that he allegedly used a vehicle in the past to assault another. And so we're going to dive into that. The judge may want the jury to know that this defendant has allegedly used a vehicle to assault his ex-girlfriend. And so we're going to just go ahead and watch a little video, maybe go through some analysis, and make your own conclusions there at the end. So let's get into the video.
That is the case where he is alleged to have struck Erica Patterson in the face with a closed fist after an argument, and then as she was walking away, intentionally ran her over with the same 2010 Ford Escape that
So literally the same vehicle at issue that we've seen in this case that they have on video going through the parade.
And then as she was walking away, intentionally ran her over with the same 2010 Ford Escape that he used in this attack. When the police went to his mother's home and found him there, he was in the Ford as they approached. He got out and tried to run into the house. He ignored their commands to stop. He tried to flee and eventually was apprehended. He lied to them and said he was not driving the Ford SUV that day, even though there was evidence to the contrary. That case is pending in Milwaukee County.
Please click the like button if you enjoy content like this, and we can get this out to more people for the YouTube algorithm. It seems like this evidence would be obviously important for the jury to know. We have like a one-to-one, apples-to-apples comparison here where he's used the vehicle in the past. You know, that's what's been alleged. And so it seems like that would be important for the jury to know, and in this case it wasn't told to the jury. And that's because of a rule of evidence, 404B. I've got it right here in front of me, so I'm just going to read it out for y'all. It says 404B, other crimes, wrongs, or acts, evidence of other crimes, wrongs, or acts are not admissible to prove the character of a person in order to show action in conformity therewith. It may, however, be admissible for other purposes such as proof or motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. So does that fit in any of those exclusions? That's the question for the judge. And this might be helpful to just do an example. So let me pull up the whiteboard here. So this goes straight back into law school. Okay, we have occurrence 1, occurrence 2, occurrence 3. And the example in law school, and I think this is a real case, but a man on his honeymoon found his wife in a bathtub, right, in the bathtub, with, and that's a horrible bathtub, but that's the bathtub we're going for in this example. And we're just going to say there was a toaster in the bathtub. And so she was electrocuted. And this happened again on his second honeymoon. So there's new wife in the bathtub, and she is electrocuted. Now, the first time, this is accident. And the second time, this is a horrible coincidence. Now, what happened was, again, he got married a third time. Bathtub, toaster. Now, the third time, this is murder. And how we get to there is the accident, coincidence, and murder. Now, obviously, the jury is going to have to decide this, but at this third time, it comes in under 404B, common plan and scheme. Okay, now we've got a pattern when we get to 3. Now you're probably thinking, now it would be really nice if we could just use this common plan and scheme inclusion for the second instance, but we'd have to apply this to all cases. And so in some cases, this truly is a coincidence. Now the third time, probably coming in. The judge still has to decide if the probative value is there for it to come in or if it's outweighed by some other factor of equity or justice. Maybe this is just a really unlucky person. Now, in this case, we have, let me see here if I can get a new page up. You know, in this case, you know, I'm not even going to try to draw a car. Just stick with me. We are, you know, actually, that's not actually a terrible car, honestly. We have two instances of him using the vehicle to assault another. This case is number 1. This case is number 2. This might be a horrible, you know, for some people. So, you know, viewer discretion here if you don't want to see this because it's, you know, very hard. But we don't have a third instance. So if there was 3 instances of this happening, if there was a third instance, and if this came down to the third instance of this vehicle being used to assault another, then I'm guessing at this point, the third time, it would probably be, you know, admissible. But we don't have that here. We only have 2. And so the judge, you know, errs on the side of caution of not allowing this as admissible evidence. I'm sure the prosecution would have loved to have admitted that, but it ended up they didn't need it anyways for the jury to find the defendant guilty. Okay, well, let's go back to the big screen here. Generally, what we have is evidence is generally admissible. It's coming into court unless there's a proper objection. And in this case, it would be an objection to 404B, other bad acts, unless you have one of those many exceptions. So 404B technically is an exclusionary type of rule because there's many types of ways that this could still get into evidence other than the one way, which is you can't bring in prior bad acts. Okay, so what should have come in? Should it have come in? Probably not because of Rule 404B, and so the judge is worried about this coming back. And so, you know, my statement is, you know, probably don't allow it to come in, or this case may come back. The judge can move forward. The judge can, you know, get onto other cases because she didn't allow this evidence in. And once again, it wasn't necessary because they still found him guilty. So they may have been, people may have been watching, and, you know, I personally didn't know that this had happened until the jury had already found them guilty, and now we're in sentencing. And so what is interesting is that during sentencing, this evidence comes in. The judge does find out about it, and the judge is truly the one that is going to be sentencing him. That is interesting. And I think the idea behind that is the judge just needs to hear everything because the judge is the arbiter of the law, and at that point needs to make the determination. And so the judge can't just close her ears to certain evidence. She needs to hear everything to determine if it needs to be admitted into evidence or not. Thank you for watching. I really enjoy these are some of my favorite videos to do. You know, the legal analysis is really fascinating to me. And so if you could click the like button, and we'll see you next time. Thanks.